Good afternoon, and thank you so much for joining Education USA for our webinar series about student visas. I'm thrilled to be here with Laura Stein from the Department of Consular Affairs. For those of you who don't know, Education USA is a network of advising centers all throughout the world. We help promote US higher education through a network of advisors who are operating in 180 countries with over 435 advising centers. We've done several different interactives. You may have even seen Laura's presentation targeting international students about the student visa process, but this is part of our new outreach series specifically for higher education institutions. Education USA is here to help you expand your international recruitment strategies and expand campus internationalization efforts. I look forward to speaking primarily with Laura today about the student visa process. Just to give you a little bit about her background, Laura has worked in the Visa Office in the Bureau of Consular Affairs at the Department of State since 2007. She is currently a visa policy analyst in the Office of Field Operations and serves as the primary subject matter expert on student and exchange visitor visa policy and procedure. Some of you may recognize Laura from the NAFSA conference or at our Education USA forum this summer. We're so thrilled to have such a great working relationship with Consular Affairs. Our staff in the field at embassies and consulates work very closely with Education USA to make sure students have the most current information about how to navigate the student visa process. So with that, I'll turn it over to Laura to guide you through the student visa process. And keep in mind, we'll be taking questions throughout the series. We'll save all of the questions to the end, but then we'll facilitate a Q&A at the end. So thanks again for joining, and Laura, over to you.
Thanks, Kelsey. So I'm very happy to join you today and present and answer your questions after the presentation. Okay, next slide, please. So this is just an overview of the topics I'll plan to talk about. I'm going to tell you first about the Bureau of Consular Affairs mission. Then we'll look at some student and exchange visitor visa issuance statistics. Then we'll look at the visa application process. And then I'll provide some updates on specific issues, including the accrual of unlawful presence and the presidential proclamation. And then last, I'll provide you with some website resources and contact information. Next slide, please. So this is broadly our mission for the Bureau of Consular Affairs. When adjudicating visas, national security is our top priority. And when adjudicating visas, every prospective traveler to the U.S. does undergo extensive security screening. And that's because we must ensure that every applicant is qualified and that they do not pose a threat to the country's security, and that is for all purposes of travel. Now, for applicants who are qualified, we absolutely do want to facilitate their travel. And we recognize that with students and exchange visitors, there are numerous benefits to them traveling here. Those benefits include a positive effect on U.S. foreign policy and the United States image abroad. We recognize that students who study here may later attain positions of leadership in their own country and carry with them the positive experiences they had while they're here. And we also recognize that there is a positive impact on the US economy as well. International students contributed more than $42 billion to the US economy in 2017, and that statistics comes from the Department of Commerce. Next slide, please. Okay, next one. So this is a snapshot of F1, J1, and M1 visas that were issued in the past 4 fiscal years. With F1 visas, you will notice that there was decreases over the last the last 3 fiscal years, and that is attributable to the November 2014 increase in student visa validity for Chinese citizens from 1 year to 5 years. Now, this does not mean that there are fewer Chinese students studying in the US. Rather, it means that they do not need to renew their visas as frequently. It's important to note that visa issuance numbers are not equal to the number of international students the US is seeing. For that, we would direct you to the Institute of International Education's annual Open Doors report, and also to SEVP's See This by the Numbers biannual report. Okay, next slide. Okay, these are the number of F1 visas that we issued to the top 10 countries of nationality in fiscal year 2018. 39% were issued to Chinese and Indian citizens. Next slide. Okay, and next slide. Okay, so where to apply? Students will usually apply at the US Embassy or Consulate that is in their home country, but they may apply anywhere that offers visa services. And this will be most relevant for those students where there is no embassy or consulate in their home country, or where services have been limited or suspended, and then they will have to apply outside of their home country. Students may check the embassy or consulate website where they plan to apply for location-specific details, including how to schedule their visa appointment, how to pay the application fee, and whether there are any additional location-specific documents that may be required. Hosts, our consular sections rather, must accept visa interview requests from third country nationals who are resident in their consular districts. And many will also schedule interviews for those applicants who are not resident but physically present in their consular districts. For example, I'm thinking here of students who are seeking to renew their visas in Canada or Mexico. It is a possibility, but students should carefully review the websites for those locations to determine whether they would like to reapply there. Okay, next slide, please. So we do keep interview wait times for all of our embassies and consulates on our website, travel.state.gov. These wait times are monitored and updated on a weekly basis by all consular sections worldwide, and we're checking even if there's been no change from the prior week. In terms of what drives wait times, it's various factors that will include seasonal demand, staffing, for example, when a host country has limited how many consular officers we may have, and then also rapidly growing workloads can affect how long a wait time is. Keeping wait times in mind, students are encouraged to apply as early as they can. To help facilitate that, we ask that you please issue and send to them their forms I-120 or DS-2019 as early as possible so they can go ahead and schedule their interviews. For F and M student visas, we can issue up to 120 days before the program start date. And with J1 visas, they can be issued at any point after the exchange visitor has presented their DS-2019. Okay, next slide, please. So this slide is an overview of the visa interview and how student visa applicants may demonstrate that they qualify. So during the visa interview, the consular officer will be considering the totality of the applicant's circumstances in determining whether he or she is qualified, including the 4 factors that are listed on this slide. So with the first 2, who they are and what they want to do in the United States, this is essentially the student telling his or her story to the consular officer. And here the consular officer may ask why he or she has selected a particular school in the United States, what they plan to study, and what they have been doing in their home country leading up to the proposed course of study. Now, to be clear, in asking these questions, the consular officer is not second-guessing the U.S. school's decision to accept the student or questioning whether the student qualified academically to be accepted by the school. Rather, through questions and interview, the consular officer is assessing that the applicant truly intends to be a bona fide student in the United States. And in listening to the student, the consular officer is also evaluating the student's ties to their home country, as students must establish intent to depart from the United States at the conclusion of their study, as well as following any authorized periods of post-completion OPT. Okay, with the third factor, how they will fund their studies, consular officers must be satisfied that the student has sufficient funds to cover their expenses while here without the need to resort to unauthorized employment. And here the applicant must demonstrate that they have readily available funds to cover the first year of their program, and that funds will be available to pay for the remaining years of their program. With the fourth factor, what they intend to do upon completion of their proposed student activities, the student must establish to the satisfaction of the consular officer their intent to depart from the United States. And here again, the officer will be considering the student's ties to their home country. It really is incumbent on a student visa applicant to be able to walk up to the interview window with the consular officer and explain these things. In terms of what schools can do to prepare students, we ask that you direct them to U.S. government resources, and this will help to steer them away from any non-U.S. government resources which may be providing inaccurate information. And I'll also give you a couple of resources at the end of these slides. Okay, next slide, please. Okay, so possible outcomes. First outcome would be visa approval. And in fact, most student visas are approved and visas issued. 74% of F1 student visa applications were approved and visas issued in fiscal year 2018. The other possibility would be a visa refusal. When a student visa is refused, it will most often be under Section 214B of the Immigration and Nationality Act. This section of law explicitly presumes that every non-immigrant visa applicant is an intending immigrant and places the burden of disproving this presumption onto the applicant. Consular officers adjudicate each application individually to determine whether the applicant qualifies in accordance with U.S. immigration laws and regulations. Student applicants must further demonstrate that they meet the student visa requirements, including a residence abroad and no immediate intention of abandoning that residence, that they have the intention to depart from the United States upon completion of studies, and that they have sufficient funds to pursue the proposed course of study. Now, if an applicant is refused under Section 214B, he or she may apply again, and there is no limit on the number of times that you may reapply. A subsequent application may be approved, and this may be because something in the application, something in the applicant's situation has changed, and they now can establish that they qualify, or simply because the applicant was nervous the first time he or she applied and is better able to express him or herself at a subsequent interview. Student visa applications may also be refused under Section 221G of the Immigration and Nationality Act, and we refer to this as administrative processing, and I'll be discussing that further on the next slide. And then applications may also be refused under Section 212A of the Immigration and Nationality Act. This section of law encompasses a wide array of visa ineligibilities to include drug possession, criminal acts, and medical ineligibilities. All applicants who are found ineligible will receive a written document, usually a letter, from the consular section at the conclusion of their interview, which explains and cites the section of law under which the applicant is ineligible. Visa records are confidential under Section 222F of the Immigration and Nationality Act. So for that reason, we are only able to discuss details of specific cases with the visa applicant. That means we wouldn't be able to discuss the details of a case with you as the designated school official or responsible officer. All right, next slide, please. So some visa applications do require further administrative processing, which takes additional time after the visa interview. This may include resolving questions about the applicant's eligibility or any other question the consular officer must resolve to overcome the refusal under Section 221G of the Immigration and Nationality Act. Timing for completion of administrative processing varies on the basis of the individual circumstances for each case. That said, we do our best to ensure that administrative processing is completed before students' program start dates. But again, keeping administrative processing in mind, applicants are encouraged to apply early to mitigate the impact of any required administrative processing. Now, for students who are refused under Section 221G, it's important that they keep listening to what the consular officer is saying to them during the interview. While this is a visa refusal, administrative processing may be followed by visa issuance and approval. So the applicant will receive further instructions at the interview, perhaps to provide additional information or documents, or to wait until the consular section contacts them. Applicants can also follow up with the consular section on the status of their case, but we do ask that they wait at least 60 days from the interview date before making that follow-up. They can also check online the status of their applications by returning to their visa application form, and I'll be providing a URL for that at the end of these slides. Okay, next slide, please. Okay, next one. Okay. So on August 9th, 2018, U.S. Citizenship and Immigration Services published a final policy memorandum on how it will calculate unlawful presence for students and exchange visitors. This policy aligns with the administration's goals to enforce immigration laws and reduce the number of individuals who overstay their periods of admission in the United States. Effective August 9th, 2018, students and exchange visitors can begin to accrue unlawful presence if they do not depart from the United States at the conclusion of their studies, including following periods of authorized practical training or periods of authorized stay before and after their program. So here I'm talking about the grace periods. They can also begin to accrue unlawful presence if they do not maintain their status as students, meaning they stop attending school, they stop engaging in authorized practical training, they stop participating in their exchange visitor program, or they engage in an activity that is not permitted while in student or exchange visitor status. Students who accrue more than 180 days of unlawful presence may be subject to 3 or 10-year bars of admission to the United States, depending on how much unlawful presence they have accrued, and they may be found ineligible for visas under Section 212A 9B1 of the Immigration and Nationality Act. Our guidance in the Foreign Affairs Manual was updated on August 9th, and it is publicly available at the second link that is on this slide. In terms of what DSOs and ROs can do with keeping this new policy in mind, please do ensure that CVIS records are accurate and correctly maintained, and please ensure that your students and exchange visitors also understand what activities they can and cannot engage in while they're in the United States, meaning that they should not take any action that detracts from their purpose of being a student or exchange visitor while here in the US. Okay, next slide, please. Okay, so prudential visa revocations. The Department of State or a US embassy or a consulate may prudentially revoke a non-immigrant visa when we become aware of information, including arrests, that calls into question whether an individual is still qualified to hold a visa. Now, not all arrests will result in visa revocation. We do consider the specific charges tied to the arrest and whether those specific charges impact the continued eligibility of that individual to hold a visa in accordance with US immigration laws and regulations. When a visa is prudentially revoked, we will make a reasonable effort to contact the visa holder to notify him or her by various forms of communication, for example, by email, by telephone, or by letter. The specific method of contact will vary by country. Again, visa records are confidential, so only the visa holder would be notified of a visa revocation. Schools and program sponsors are not notified, so it would be incumbent on the exchange visitor or student to notify his or her RO or DSO. In terms of when prudential revocations take effect, they are effective immediately upon departure from the United States. So this means that the individual would need to reapply for a new visa in order to return to the United States and seek entry with U.S. Customs and Border Protection at the port of entry. There is no set time frame for when a visa holder must reapply following revocation. The individual determines when and if he or she would like to reapply. Okay, so when we talk about prudential visa revocations with schools, it is often regarding those that were revoked following DUI arrests. So I'll focus now on that specifically. The Department of State takes seriously drunk driving, driving under the influence, and driving while intoxicated. DUI is both a public safety issue as well as evidence of possible visa ineligibility. In November of 2015, the Visa Office implemented a requirement that consular officers at our embassies and consulates prudentially revoke visas issued to individuals subsequently arrested for DUI, unless that arrest has already been addressed within the context of a visa application. Driving under the influence is indicative of possible visa ineligibility for physical or mental disorder with associated harmful behavior, which is Section 212A, 1A3 of the Immigration and Nationality Act. Consular officers are required to refer any non-immigrant visa applicant with one alcohol-related arrest in the last 5 years or 2 or more in the last 10 years to the panel physician for a medical examination to evaluate that applicant's medical eligibility for a visa. Previously, there was no review of DUI arrests subsequent to visa issuance until that individual applied again, which could be up to 10 years later, depending on how long their visa was valid. Okay, next slide. So I'll speak now about the presidential proclamation. Certain nationals of 7 countries may be affected by presidential proclamation 9645. And those countries are Iran, Libya, North Korea, Syria, Venezuela, Yemen, and Somalia. Now, with regard to F&M student visas and J exchange visitor visas, nationalities of only 2 countries are impacted. And those 2 countries are North Korea and Syria. Individuals who may be affected by the proclamation should review our up-to-date guidance on travel.state.gov. The website includes guidance for applicants who may be eligible for exceptions and would therefore not be subject to travel restrictions under the proclamation, and it also provides guidance on waivers. An individual who may be subject to the proclamation should disclose during their interview any information that might qualify him or her for an exception or for a waiver. In coordination with consular section management and following any required administrative processing, the consular officer will carefully review each case to determine first if the applicant is affected by the proclamation, and if so, whether that application would qualify for a waiver. Okay, next slide, please. Okay, next one. Okay, so there are various websites available to help students navigate the visa application process and to prepare to apply for their visas. I've mentioned several times already Consular Affairs website, travel.state.gov. This site hosts links to all embassy and consulate websites, as well as all information about applying for a visa. For prospective students, we also recommend EducationUSA's website for information on the learning opportunities available in the United States. And then j1visa.state.gov is the Bureau of Educational and Cultural Affairs website detailing each of the 15 exchange visitor program category, including the various student and scholar categories, as well as information on other topics, including program sponsor designation. And then I also always like to highlight SEVP's Study in the States website as an additional excellent resource. Next slide. Okay, contact information. Students who have already applied but have follow-up questions may contact the embassy or consulate where they applied. and contact information for each location is accessible from travel.state.gov. For general questions, students and school officials may contact the National Visa Center at the number that is listed on this slide, Monday through Friday, 7 a.m. to 12 midnight. And then students whose applications are refused under Section 221G of the Immigration and Nationality Act for administrative processing, they can check the status of their application using Visa Status Check by returning to their DS-160 online application at the URL link that is at the bottom of this slide. Okay, next slide. And we're now ready to take any questions that you have.
Wonderful. Thank you so much, Laura. I think that information was incredibly valuable, and hopefully the U.S. institutions who tuned in are able to better understand how the process works, how they can engage with Consular and also with EducationUSA. Our advisors in the field are always happy to connect both with students and with U.S. institutions about the entire student application process. And the visa process is, of course, an important part of that. So I would just encourage all those of you who are still tuned in, please feel free to ask any questions that you have, and I'll direct those to Laura about student visas. Certainly also happy to answer any questions about EducationUSA resources more broadly. So looking here, it seems like we have some questions in the queue. So here's one. If a student obtains a visa for one university, but then later transfers to another university, does that require a new visa?
So actually it does not. So for example, a student who was issued a visa, let's say it was valid for 5 years. If they enter the US, they start attending the school that the visa was issued for, but they later transfer, the visa remains valid. So they don't have to go and apply for a new visa as long as that visa is still valid. Now, when they enter the United States, they of course should have with them an I-20 that was issued to them by their new school, and present that at the port of entry along with their still valid visa.
Okay, that's really helpful. I know something that we've been talking a lot about is articulation agreements that exist between community colleges and four-year institutions, and a lot of international students are considering starting at a community college and then transferring to a four-year institution, and that's worked out really well for a lot of students. So it's helpful, I think, in that context to understand that a new visa wouldn't be required.
Right.
All right, thank you for that. All right, here's another question. What is the time frame schools should tell their prospective students to begin the visa process?
So, as I said when I was giving the presentation, we do want students to apply as early as possible. Keeping administrative processing in mind, keeping in mind longer wait times, particularly in the summer, particularly at the end of summer, student wait times can grow. So we want you to apply as early as possible. A student visa can be issued up to 120 days in advance of the program start date. So students would want to keep that in mind as well when deciding when they want to apply for their visas.
Okay, that's really helpful. Good to keep in mind and good to communicate with your students as they go through the application process. So here's the third question. After visa approval, we had a student cut all communication with the college. We ended up terminating the initial I-20, but the student was still admitted at the point of entry. And of course, they disappeared. Is there anything else we could have done besides terminate the I-20? So from the institution point of view?
So a couple of things are in play here. I would say this would probably be a question that would be better addressed to SEVP and maybe to Customs and Border Protection as well. They're not with us today. I don't see that there's any other action, unfortunately, that the school could have taken. At the port of entry, they do have access to that information when a school terminates an I-20. It is still at the discretion of CBP whether to admit that student again on their visa.
Okay, thank you. So what are some tips that universities can provide the students when preparing for their visa interview?
I can't say it enough. Apply early. Apply early. And do direct them to travel.state.gov and the other US government websites for information. If there's any outreach that may be happening at the consular embassy where they plan to apply, they would also learn that information by connecting with the embassy or consulate they plan to apply to. So again, official U.S. government sources versus non-official, non-U.S. government sources, which may provide inaccurate information to students.
Okay, I think that's really good advice. And, you know, engagement with an Education USA advisor can help make sure that they have access to the most current information, understand the timeline, and then also focus on the whole of application. So it's great to have that sort of collaboration. So if a student's visa is revoked due to a DUI, is he or she permitted to remain in the United States for the duration of his or her status?
So the visa really only becomes an issue when they depart the United States. So when they seek to re-enter, obviously they'll need to apply for a new visa if the visa has been revoked following a DUI. That said, of course, you know, ICE, the Immigration and Customs Enforcement, is responsible for monitoring those students in the United States. That's not to say that they would necessarily take any action against the student, but that should be kept in mind.
Absolutely. Okay. What information can you provide universities if a student has been accepted to a university but was denied a visa? So you talked a little bit about this, but of course it's a popular question.
Right,
so any other insight you might be able to offer?
So students who have been denied when they initially apply may reapply. They may subsequently be approved if something in their situation has changed. If there's some information they did not disclose or share with the consular officer at their first interview, they may be able to establish that they qualify at a subsequent interview. And then I think also nerves can play a big role in the visa interview process. You know, coming in and talking to a U.S. government official can be daunting. So, you know, if they've gone through the experience once, simply reapplying, maybe being less nervous the second time around, they may ultimately be approved at a subsequent interview.
Okay, that's helpful to know. Thank you. To follow up from a previous question on visas and I-20s, if the student leaves the country and waits longer than 60 days to transfer, can he or she still just get a new I-20 and pay a new CVIS fee to attend a school without applying for a new visa, as long as the visa is still valid?
So if the student's visa is still valid, they can still use that visa to apply for entry at a U.S. port of entry. If the visa has expired, then they would need a new visa. So we're talking here about whether the student is admissible. If they still have a valid visa, they wouldn't need to apply for a new one, but CBP would determine whether that student should be admitted to the United States.
Okay, that's helpful. If someone participates in an exchange program in the United States on a J-1 visa and wants to study at a U.S. university, do they have to spend 2 years in their home country before they can apply for an F-1 visa?
So here, the question is relating to the 2-year rule that some former exchange visitors are subject to, where they have to, the 2-year home country physical presence requirement, where they may need to be outside of the United States for 2 years. It's only if they are applying for visas in certain classes, including immigrant visas, H-1B visas. The F-1 visa is not one of the visas where they would have to wait the 2 years before applying. This is kind of a weedy topic. Section 212E of the Immigration and Nationality Act, this 2-year home country physical presence requirement. So I would direct you to travel.state.gov. We have a whole series of web pages devoted to this topic where you can learn more about it.
Okay, that's really helpful. You know, so we're here live at the Bureau of Educational and Cultural Affairs, and so, you know, we see a lot of our alumni of U.S. government exchange programs then go on to study in the United States, which of course we encourage and are so
Yeah.
happy to see them come back. But of course, very important that they're following all of the regulations of their visa. So that was helpful to understand that context, and would encourage institutions to do some additional research, as Laura mentioned. All right, next question. Do students have to demonstrate a certain level of proficiency in English in order to receive a visa to study with an intensive English program in the United States?
So with student visa applicants, we are looking at their I-20 in terms of whether or not English is required for their program of study. So a program of study where the I-20 indicates that English is required, we would generally expect to be able to converse with the applicant in English. Now for an intensive English program, assuming their I-20 does not reflect that English is required, then we wouldn't have that same expectation that the student be proficient in English and able to communicate with the officer in English at the interview.
Okay, that makes sense. All right, next question. Should we advise current students from Iran preparing for an F1 visa renewal application differently than F1 students from other countries? So I think referring to the presidential proclamation.
Okay, so as I said during the presentation, with regard to the proclamation, it's nationals of only 2 countries for whom issuance of F1 and J1 visas have been limited, and those are North Korea and Syria. So Iran, nationals of Iran are not impacted with regard to student and exchange visitor visas. As I said, for all applicants, we urge students to apply as early as possible. For renewals, although of course you can't apply from the United States, you can't simply mail in your passport and seek a visa renewal. Students could, however, go ahead and schedule their visa interview while they're here in the United States, so that they'll be prepared to go ahead and apply immediately once they depart.
Okay, thank you. And I think it's important that institutions remember that distinction between F1 and J1 visas and other types. If a student is bringing a dependent with them to the United States, does the dependent need their own visa?
Yes, so for all FM and J programs, the designated school official or responsible officer should be giving any spouses or children their own Form I-20 or DS 2019, which will allow them to apply for their visas. Yeah, so they do need visas, and they will need their own Forms I-20 or DS 2019.
Great, that's important to note. All right, it looks like we just have one more question. How can smaller, lesser known institutions, such as community colleges, help their prospective students be successful in the visa application process?
I think really everything we've already covered in this presentation, really it remains the same. I would highlight that we adjudicate each application and each applicant on the basis of their own individual merits. So we're not adjudicating on the basis of the school that the applicant has selected, whether it's a small school or a community college, as compared to a large college or a large university. Rather, we're adjudicating on the basis of the applicant's qualifications. As we've said, do refer them to our U.S. government resources for more information, and urge them to apply early, please.
That's great. Okay. Thank you so much, Laura, again, for answering these questions and for helping provide really valuable insight for our U.S. institutions. Before we sign off, do you have any sort of closing comments or any other issues you wanted to address?
Really, I don't. Thank you very much for having me today. I appreciated the opportunity to present and to answer your questions.
Okay, thank you so much, and thank you so much to all of you. We're trying more and more to engage U.S. higher education institutions into our international student mobility efforts. You're incredibly important in helping bring students here to the United States. I encourage you to stay involved with Education USA, check our Education USA social media pages, and the HEI monthly newsletter for information on the next Education USA webinar. Also, we have resources to help promote your own school's recruitment. You can check our website at educationusa.state.gov, learn more about our global guide, the open doors numbers, and different strategies for helping increase your international student recruitment. Thank you so much again for joining us, and thank you so much, Laura. We hope to see you next time here with Education USA.